Welcome to Law and Society. Today's question is: will SCOTUS disqualify Donald Trump? How should the Supreme Court rule in Donald Trump's disqualification case? So, if you're new to my channel, please like and subscribe, and let's dive in. A quick review. I wanted to point out the main legal issues that are at issue in this case. The the government's position, I'm sorry, not the government's, Colorado, Colorado Secretary of State and Colorado electors' position is that states have the right to determine candidate qualifications based on Article 2 and the 12th Amendment and the 10th Amendment. That is where Colorado electors and the Colorado Supreme Court found that there was a heavy state authority in being able to do what they did. So the basis of Colorado's case in favor of disqualification is based on the state's ability to enact laws and administer laws for candidate qualifications and even allow uh, citizens of Colorado to challenge candidate qualifications by state law. And that authority under the Electors Clause in Article 2 of the Constitution and then 12th Amendment falls squarely within state power. And because of the 10th Amendment, absent congressional legislation on this matter, states can step in and administer their laws, and each of the cases should come up to the Supreme Court. Now, and be determined piecemeal. That's one position. The Donald Trump's position in this case is based on a precedent, which is not Supreme Court precedent, in Ray Griffin, in which a federal circuit held that only Congress can be the one to enforce Section 3 of the 14th Amendment. And there is legal history based on this Griffin case. And the legal history shows that Congress enacted a law that may have been influenced by this Griffin ruling. And that law governed the enforcement clause of how to apply Section 3 of the 14th Amendment. But that law was repealed in 1948. And so today, Griffin's case is the only strong argument that Donald Trump's attorneys have to say that it is up to Congress, that states have no authority to disqualify a candidate. So I wanted to point that out because these are the two competing legal issues at balance. On one side, the state and citizens of Colorado are saying that we have a right under Article 2 of the Constitution, the 12th Amendment to the Constitution, and the 10th Amendment to the Constitution to be able to enact laws and then put them into and then enforce them by state enforcement procedures of candidate qualifications, because we have power under Article 2 and the 12th Amendment. And we can then legislate on that matter absent congressional legislation, because there is no enforcement mechanism for the disqualification clause, other than saying that only Congress can. Whereas in Colorado's case, Congress did not, but Colorado did. based on the 10th Amendment saying unvested powers go to the state. And so the constitutional argument that holds Colorado's case is constitutionally stronger, in my belief, than Griffin, which is not only not a SCOTUS precedent, but also a case that may have influenced an enforcement statute that was later repealed. And both Justice Kavanaugh and Donald Trump's attorneys concede that 18 USC 2383, rebellion and insurrection, that statute, which includes the mandatory punishment of disqualification from holding public office, is the only remedy. But as I have stated before, and I hope that Colorado's attorneys argue, that the difference between the disqualification clause and 18 USC 2383 is that the disqualification clause leaves the remedy of Congress being able to remove the disability of disqualification, whereas that is not present in 18 USC 2383. So it would favor Donald Trump to go by the argument of Section 3 being enforced through the enforcement clause, which does not exist because Congress does not have a law on the books right now, than for him to apply the other way. And that's what they have done. They have gone with Griffin and they have said Congress can only enact laws, and Congress has not. Well, the flip side argument is stronger, in my belief. So, how I think the Supreme Court should rule is that every state has the power and authority, absent congressional legislation and enforcement, to determine how candidates qualify, how and whether candidates qualify to be on election ballots. It's a very specific issue that is, it's not just the 10th Amendment that Congress is silent and therefore states can legislate and enforce. It's also that Article 2 and the 12th Amendment vests in states and state legislatures the power to legislate election matters. And it gives Congress that power as well. But Congress has not legislated on candidate qualifications. So that's how I think SCOTUS should rule, that each state has the power to enact their laws absent congressional legislation and then determine which candidate is qualified. That would effectively affirm Colorado's ruling and then leave it up to the other states to determine who they can put on their ballots. And should that case come up to the Supreme Court, it can then rule based on this particular case and distinguishing from this case whether there was due process considerations, etc. But will SCOTUS rule that way? I don't know. What I just told you is my hope that a wise Supreme Court would enact. I'm not saying what I'm saying is wise. What I'm saying is the argument presented by Colorado and the argument presented by Donald, the legal constitutional argument is stronger and in favor of state procedure absent congressional legislation. And another thing, all the other provisions of the 14th Amendment are you know, as Donald Trump's attorney conceded, are self-executing. So, absent congressional legislation, why Section 3 wouldn't be self-executing is uh, is a question that the Supreme Court should resolve, and it should resolve it by saying that the enforcement of it is self-executing to the extent that it trigger is somebody does engage in insurrection, and then due to the state's power, plenary power in determining candidate qualifications absent congressional legislation, that states then have the power to determine whether disqualification is proper for their state, and then make the constitutional argument of saying that we are going to say that the disqualification attaches automatically, just like any other disqualification would, because of, you're not born in the United States, you're not 35 years of age, and I think there's some residency requirements, but being of natural born and being uh, born in the United States, and then the age requirement, and then what Colorado is saying is that uh, you know that disqualification clause becomes part of that um, qualification list, and uh, and that becomes the state's authority to determine when they are in a position to determine candidate qualifications. So I think that, but then this Supreme Court, may very well go in the direction of Justice Kavanaugh and say that we're not, we're going to say that the enforcement clause is the only way to enforce, and Congress has enacted, and 18 USC 2383 is the only way to go about it. Because in the oral arguments, and I don't think even in the briefs, Colorado argued that 18 USC 2383 does not that the is not distinct from the disqualification clause in Section 3. But that may be something that they bring up. They may say something along the lines of Colorado does not have the power to dictate for all other states. But Colorado's Secretary of State's attorney made that argument that each state has the power to do it, and each state should do it in their manner, and then bring it up to the Supreme Court. So uh, then there's the ripeness question. The Supreme Court asked about whether, it was even the right time to bring up this suit. And yes, now is the right time because of the whole economy of it all. Because you're going to go through the process of having a candidate and then have to adjudicate it at the very end. Should he win, why not disqualify him now? So the rightness argument also comes up, and we're going to have to see how that unfolds. Excuse me. With that said, that's my projection of the direction in which it should go. The Supreme Court should narrowly affirm Colorado's opinion and say that states have the authority, the plenary authority, and not take away from states' rights or from states' rights that are enunciated by the Constitution under Article 2 and the 12th Amendment itself. That right is a vested right under the Constitution versus Donald's argument of Griffin that says only the enforcement clause can enact the disqualification clause. That would make it a far more it's a far less weightier constitutional argument that bases it on legal dicta, which is now legal dicta, as opposed to the Constitution itself and the amendments. So, for a textualist and constructionist court to rule anything other than giving states rights in the absence of congressional legislation, and then making sure that it applies only to Colorado, to make it a narrow ruling, but keep open for other states their ability at any time that their laws command it, absent congressional legislation, be able to go through the disqualification procedures and then go through the judicial review and come to this court. And that's what the court is there for. And I believe that the idea of the burden of the Supreme Court of dealing with all of the cases. Well, if you think there's a burden, then just leave it up to the states and say, the last judicial review that can happen in this case will be through the state courts. You can say that in your ruling. Go through the state process, go through the state courts, and the state courts will become the last arbiter of it. You can make that argument. So anyway, I've gone on now for 16 minutes. And hello, Tony. Thank you for being here. I don't see any questions. So, if it happens. Well, the thing is, after the election, the matter of whether he becomes something that can go on, but the states won't be having another election for which he stands until when the time comes. So the ripeness argument for the next successive election is much stronger. We're talking more about this election, and because of the primary process, time is of the essence with these rulings, which is why I believe even the Supreme Court put out a statement saying that it will make a ruling on the disqualification issue, because Colorado and Maine, two of the three states that has disqualified Donald Trump, their primaries are on Tuesday. So, there are ways to expedite litigation. And, we go back to Bush v. Gore all the time, talking about how quickly SCOTUS can act. SCOTUS can quickly act by saying, we give it up to the states. It's up to the states because Congress hasn't acted, as opposed to do something that the right-leaning justices have always accused the left-leaning justices of doing, by taking judicial dicta and making that into Supreme Court precedent. That undermines the Electors Clause, and that undermines the 10th Amendment, states' rights. So, the potential burden places on the Supreme Court is far outweighed by the constitutional destruction that will happen if they were to say, no, only congressional enforcement can happen, and we are upholding Griffin, which is not even a Supreme Court precedent. And we're also going to say that 18 U.S.C. 2383 is that constitutional enforcement. That congressional enforcement through which the disqualification clause is enforced. But then that comes up against the wall of the argument that, well, if insurrection rebellion is the only way to go about it, then remember that statute does not include the remedy of 2/3 of Congress being able to remove the disability. So that would also become a constitutional concern. And had Congress wanted 18 U.S.C. 2383 to become the replacement for a statute that was there to enforce the disqualification clause in the first place, then 18 USC 2383 would have said so, but there's no legal history of that happening. So, the case, the way that the questions were asked, many have said that, oh, the court will rule in Donald's favor. And, many experts have said that. And I believe that, it very well could happen. Everything I've just told you could very well be wrong. And, I always am open to that. But I will maintain, even if I'm wrong, that the method through which the court goes by jumping to Griffin, then going to enforcement clause, then saying 18 USC 23 is a far weaker constitutional construction by this court than would be upholding a state's rights under the 10th Amendment and the state's plenary authority to determine candidate qualifications absent congressional legislation under Article 2 and the 12th Amendment. That power comes straight from the Constitution. So I think that argument, I don't remember it being made in that way. So maybe we'll see the court will talk about that. So we expect an opinion coming out on Monday, which is today. So maybe in a few hours. And so I'll be talking about that when I wake up on the other side of the earth. So I'll probably be late with that. But this is what I feel should happen. Deb, thank you again for being here. And I don't see any questions. So I'll end it here and I'll talk to you again when the opinion comes out. Take care.